Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice group of Roetzel and Jonna. And today I'm joined by healthcare partner Jonna Eimer, who's going to talk with me about letters of intent and some of the unusual and challenging aspects that we face when clients sign an LOI that they don't understand, when they surround themselves by a team that gives conflicting or incomplete information, and some of the misunderstandings that sometimes arise between the time that you sign an LOI and when you receive the actual deal document. So that's a lot to cover, but we're going to dive right in. How does that sound?
That sounds great. Thanks for having me, Ericka.
All right, perfect. So we have a lot to cover. And first, let's talk about the LOI. We know what the basic terms are, and I've covered this in podcasts before. What are some of the issues that you see where people don't understand what they're signing in an LOI that can often lead to misunderstanding and maybe even a failure of the deal?
Yeah. Well, what I see is people often, because everyone's so excited in the beginning of the deal stage, right? They want to sell, the buyer wants to buy, and they sometimes can rush into this LOI. And they often get stuck on that provision that says this is non-binding, which you and I know it is hopefully non-binding, but depending on how it's worded. But I think that often can make people just jump in maybe a little too quickly to sign without really thoroughly understanding the terms of the LOI and understanding that the other side might have really strong expectations that those terms will stay in. And you might think, oh, we'll figure them out. That's what some people feel like that's what non-binding means, that they're not the final terms. But oftentimes an expectation is created, and that expectation then also can reduce your leverage later on if you really did think you had a lot of room to change these terms. So that's one of the first things that I think I encounter, and you and I have talked about this and how we really feel strongly about making sure the client understands what they're signing early on.
Right. I think that's important. And I think the expectation is that at least the business terms are going to be honored. There won't be any major swings, but sometimes there are things that come up in due diligence that can lead to changes, of course. I think, a lot of times there's just not a lot of information in the LOI. So there's only some basic terms. So when you're trying to explain to the client, you can only explain what's there. And a lot of times we get pushback when we try and ask questions or try and see if we can get some more information. And they'll say, well, let's just get this signed and that'll be worked out in the document. And unfortunately, that is often what precipitates an LOI being signed without a full understanding. And it's nobody's fault, and just sometimes, only the basic terms are worked out. And then when the buyer, for example, starts talking to their tax and financial and legal advisors, and they put some meat on the bone, so to speak, it turns out to be something different than perhaps the seller had imagined. So there's really no misleading intent in the LOI. It's just sometimes once the deals are worked out, it's not what both parties anticipated. Right?
Yeah. And I think that's exactly the case, right? There's some vagaries that we'll deal with later on, and we flesh them out as time goes on in the due diligence process, which is the point of due diligence, right? So we shouldn't expect that the LOI goes through every single term or every expectation of the deal. That is exactly the point of due diligence, to get into that process. But the big picture items we want an understanding of moving forward. But definitely the details, that's what we uncover, and that's what your advisors and lawyers are doing as you move into that diligence process, because not every term or detail or implication or tax effect or the way the consideration is paid or earnouts, all those exact details are not going to be figured out in the LOI. So we certainly aren't meaning we need to do that. We just want to kind of be all going in the same direction. And that's where you and I have said we always advise to our clients to quickly obviously have us involved, and we'll do whatever we can to guide you correctly, but bring in your accountants and financial advisors early on if possible to guide you from that perspective as well.
Right, I agree. And, oftentimes the clients want to negotiate the LOI themselves. So you may make a couple of questions and comments, but then next thing you know, it's signed. And a lot of the reason for this is that the buyer's business people are the ones negotiating on the other side. They're not really involving their legal counsel. So sometimes there is a disconnect between the offer that's made and actually how it needs to be structured legally, tax-wise and otherwise. And that can sometimes create a bump in the road once we actually receive the legal document, and that can be the disconnect that ends up occurring, which happens pretty often, but 99% of the time, experienced lawyers kind of work through these issues that were not fleshed out at the LOI stage and kind of figure things out. And that's really part of the expected process. So I think for clients that think that they sign the LOI and then the documents come and they exactly match the LOI and we close, like that is not it at all. There's legal work, there's discussion, there's tax review, there's structuring of the entities that has to be involved. And I think, clients need to understand that it is a process that's quite involved.
Yeah. And the business people, like what you're saying, they often do want to get this signed and accomplished, and they're not wrong. And we're here to help them with that. We're not trying to get in the way of deals moving forward, but these business people may have multiple deals in multiple jurisdictions, and they might draft a very general LOI without a firm understanding of the laws of a particular state or area and how they might affect the intricacies of that LOI, which you and I know because we know Illinois and other places where we're doing deals have specific rules and implications with respect to how these deals can be structured, and that can ultimately affect how the ultimate deal documents might look.
Right. And I would say even if the LOI doesn't go into enough detail or spell things out, there's solutions to everything. There's a way to structure every deal.
Yeah.
I think part of the issue is that everybody has to remain flexible. And if you're inflexible, that can kill a deal.
Yeah.
So I think going into it, there needs to be an understanding that these are basic terms. Some things may change, but the parties are going to work together in good faith to achieve what was ultimately the goal. And I think if everybody is very black and white about it has to be this way because I expected it to be this way, then it's unlikely that a deal can be done.
Yeah.
Right.
And if there is if the client really does have a firm belief or expectation of a particular point, it's important for them to communicate to you or I or their legal team that, but for this particular provision, I wouldn't do the deal. Right? Because we don't know that, and we don't know, all of us know a lot of smart people. We might be getting other advice. And if you're not sharing that with your legal team or your accounting team, we don't know that was the most important part of this deal for you. So you have to, while I caution you to have too many people whispering in your ear as a client, because sometimes those people, they have very different deals or different laws apply, or they're not telling you the whole story. So certainly, I'm not saying no, listen to other sophisticated, smart people, by all means do, but share those conversations with your direct advisors so we are in on it together and can guide you. And if there is a very, very important part of this deal that you really need to happen, then we would, of course, focus on that right away to make sure that at least was clear from the start.
I think that's really important. And I've always emphasized that you need a team, but you also need to trust your team. And if you're not going to trust your team, and then that's not the team for you. It's really difficult to represent a client when they listen to everybody's advice but yours and your experience in doing these kinds of deals. So I always recommend a great accountant. And when I say accountant, there are accountants who do like file your taxes, right? But that's not necessarily the right kind of accountant who's going to help you through a deal to understand the structure and the tax implication. And lawyers, although some do, really need to stay in their lane and give the legal advice and should not be giving the financial advice. Plus, we don't have access to the client's financials. We don't know what their tax status is. We don't know, what their numbers look like and what the ultimate amount of taxes are that they could end up paying, right? So we don't have that information. So we do need to work together, but I think it's important to understand the role that each party plays and to have those people talk to each other so everybody's kind of on the same page. And I know that we usually work with a tremendous team of financial advisors. When we do these deals, we always can make great recommendations on people who help get deals done. And I think that's really the key thing. You want to surround yourself with a team of deal makers, not deal breakers. There are solutions to every problem, but if you're not going to work to find a solution, then there won't be one, right?
Yeah, I think that's a great point, because while there's, a lot of smart lawyers, a lot of smart accountants, but if they don't have the experience in the area that you need, they can't necessarily advise you on your particular deal. So while they might be really good accountants for your day-to-day and your business needs, when you're doing, like when we're doing a healthcare transaction, if they don't have experience in those particular deals, they might not be able to guide you as effectively as someone who's doing deals like this all the time and really knows what to look for.
Right. So when we're looking at an LOI, what would you consider kind of to be these central elements that are the things that you should not expect to change? From my perspective, I expect to understand, what the purchase price is, or at least how it's being computed. I expect to understand whether everybody's being retained, like all the sellers, if they're staying on. I expect to know if there's going to be rollover units, what percentage of the purchase price is being allocated to that, right? I would expect to know if we're going to see some, restrictions, whether it's non-compete or otherwise. And I don't expect the detail on it, but just to mention that that's going to exist in there. So and also if the compensation of the sellers going forward is an important element, I would expect that either we're told they're going to maintain how they're currently getting paid or some mention of how that's going to be computed, because the deal is not only the purchase price, but if you're committing to 5 years, how you can expect to be paid for those 5 years. And speaking of 5 years, how long a commitment is being made. So I would expect those things to be there, and I'm sure you have other things you'll tell me in a second, but I also expect that almost everything else could change. How exactly we're going to make the payments. Is some of it going to be tied to an earnout? Of course, some mention of that in the LOI is quite nice. Who else is being hired? I would expect in the LOI to see, is there going to be some money put aside and what percentage for escrow, right? But really, there's like maybe 5% of the deal is in that LOI and the rest of it is not. Would you agree with that?
I do agree. And I agree with you. Like primarily we want to see like those key business terms included. And those, I think there's a real expectation that those will not change unless something really significant came out in the diligence process to change everyone's understanding of the business terms in the financial deal. But the business terms, definitely, I expect to see those in the LOI. I expect to see, like you said, the non-compete employment compensation issues generally going forward, what those expectations are. And then another thing is the liabilities, right? What liabilities are we taking or not taking with respect to taxes or employees? All those I expect, even if we're not going to itemize them, right? Are we expecting to take a lot of the liabilities or really none? And are we taking the assets and no liabilities other than those specifically documented in our transaction documents? So I think those are very important. And are there any excluded assets? So you and I have both been involved in deals where there's certain assets that are not part of the deal. Maybe they're owned individually by someone, or maybe there's real estate that's separate. So all of those need to be accounted for as well.
Right. And, I would say most of the time, though, we don't really see a lot of detail on liabilities in the LOI. Usually we'll just see a statement, we're not assuming any liabilities, right? And then they may at that time not even know like what is going to be excluded because they didn't realize somebody owns a car or somebody owns, the real estate should be mentioned, like we'll be taking over a lease or we'll be buying the building or something like that. But a
Yeah.
sentence. Like these
Maybe.
LOIs are typically like 2 pages,
They're
maybe
quick.
3,
They're
right?
quick.
Yeah.
They're quick. But
Very, very short. So,
yeah.
but generally, I don't see buyers assuming liabilities, at least at the LOI stage. Maybe
Mhm.
there's a reference to subject to diligence,
Generally,
right?
generally,
Something
yeah.
like that.
I will
Yeah.
say sometimes though we see stuff about whether or not cash or receivables are included or excluded,
Right.
a working capital, adjustment at closing, things like that. Again, briefly, they might just be touched on, but we might see some mention of that. Things that are
Right. And of
material or
course, you and I,
or,
we would love to dive in and like add way
yeah,
more
yeah,
information, but that is something that typically, is not
yeah,
necessary to get past the LOI stage. We know that's going to be
yes,
part of the
yes, definitely.
process, unless there's something really important. Like you said, if the building being part of the deal
Yeah,
and
you
a
would,
long-term 7-year lease being
yeah,
part of the deal, then absolutely that has to be in the
yeah,
LOI, right?
yeah, yeah. If
If
you
it's
wouldn't
not,
do this deal without this
yeah.
term, this provision, then we need to put it in the LOI, and that needs to be communicated to your lawyers, because then of course we'll make sure that term is added, or sometimes like a big provision, like you said, is employees. They want to know really an understanding that all the employees, or at least almost all the employees, will be hired and on substantially the same terms. That's often a big deal for sellers as well. So
Right.
again, if there's something that you feel strongly about as particularly a seller, that you wouldn't do this deal without, then we need to make sure that that's it in the LOI for certain.
Right. And there's so many, and it's such a unique thing. Every seller has things that are important to them.
Yeah.
And I think for the most part, other than the dollar amount, when the money's going to be paid, when they might close, that's what most sellers really care about.
Yeah.
So even some of the items we're talking about don't necessarily come up in discussion as being important at the LOI phase, because we know we're going to see more details. So, all right. So to summarize, I think what we're talking about, surround yourself with a team of knowledgeable people. Let them talk to each other and make sure you trust them. If you don't trust them and you're going to be listening to everybody but them, then this isn't the team that you should be working with. I say that's the first thing. Second thing, understand that the LOI is going to have some terms, but not all terms. And you need to at least be in agreement with the basic terms that are in the LOI. And you need to let your advisors know if there are certain things that are more important or less important to you so that they can be touched on in the LOI, with the understanding that you need to remain flexible for when 99% more of the details become available at the time that the agreement is actually provided to you, right? And then I guess I would say is, those to me are really kind of the key things. What else would you add to that list?
Everything you're saying, I completely agree with. And then I think just trust the process, right? Things may change, and there's things that we're supposed to do as your advisors, and the back and forth that goes on after the LOI, the diligence process, is when a lot of these more minute details are fleshed out. And allow that. It doesn't mean that the LOI wasn't entered into in good faith, or was intentionally misleading, but there are things that the business people jump right into and get into they want to get the LOI signed, and that's great, but then allow us to do our jobs and allow us to do that back and forth and diligence process to clearly, flesh out all these details and uncover things that might need to be uncovered that could, potentially change the deal. And as you and I have talked about too, that's an essential part of the process. The diligence is for that, for all this information to come to light, including, as you and I discussed, that whether there's the fit there, right? That those are the things that the intangibles that you can't even account for in the LOI stage, that as you're doing this back and forth post LOI and in this diligence period, do you fit together as a buyer and seller who are going to be in this long-term relationship, like you said, potentially for 3 to 5 years or more? So I think those are, I agree with what you're saying. It's just
I think that's
important.
One of the things is, we've done so many of these deals. We've both been practicing about 30 years, and very rarely do they not go through. Very, very rarely. I can, think of just a few
Yeah.
instances. Usually it has to do with things that come up in diligence, maybe regulatory, maybe financial. Sometimes the quality of earnings shows that, the purchase price was not justified, and yet the seller is not willing to consider different prices are all legit. But sometimes what happens as well is that in the back and forth, the seller and buyer realize they don't really like each other, right? I've had sellers who just don't like the way they're spoken to. They don't like how their concerns are dismissed, and they feel like it's a little bit of a red flag. I'm working with you, but if you won't listen to me now, will you listen to me later? And I think, so that's a great point that you mentioned. Just also using this process as a way to know whether this is a good fit. It's not all about money. If you're committing to work somewhere for the next, 5 years or whatever it is, you have to be happy living for the next 5 years. So I think that's really important.
Yeah, it's a big decision. It's a big undertaking. And I think it's just important, as you said earlier, to trust your advisors. Each step in this process has a purpose, right? The LOI, the diligence, and the documents, all these things serve a purpose. And we as your advisors are here to help you through that.
Great. All right. Any final thoughts on this?
No, I think we covered it. I think it was
Okay,
great.
perfect. If anybody has any questions about an LOI they're considering entering into, any assistance that's needed in understanding a transaction, we hope that you'll feel free to reach out to us. And please be sure to check out our other podcasts at ralaw.com. This is the Health Law Hotspot, and we'll see you next time.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.